Will you grab the attorney? Yeah, thanks. All right, good morning, everyone. I'm going to go ahead and call the case. This is the time set for in the matter of Kelvin Richardson versus Anthony Mitchell Williams. Can I go ahead and get appearances, please? Beginning with counsel for the plaintiff.
Yes, good morning, Your Honor. Kevin Whitaker on behalf of Kelvin Richardson, who is present and seated to my right.
All right, good morning. And Mr. Richardson, can you go ahead and stand and introduce yourself, please?
Kelvin Richardson, the plaintiff.
Good morning.
Good morning.
And do we have, let's go ahead and keep getting introductions. Whom do we have on for the defense?
Good morning, Your Honor. Corey Langhoffer for the defendant, Anthony Williams, who's seated here at counsel table. In the gallery, we have Kirk Adams, who we expect will be testifying today, some private security, and then a assistant from my office.
All right, good morning. Mr. Williams, can you go ahead and stand and introduce yourself, please?
Yes. Anthony Mitchell Williams II.
Good morning. And you, Mr. Langhoffer, you said Kirk Adams is going to testify as well?
That's correct, Your Honor.
All right. Mr. Whitaker, do you have any witnesses?
No, not today, Your Honor.
Okay. Well, at this time, I'm going to ask all of the parties and the witness to please stand, raise your right hand, because my clerk's going to swear everyone in as required by one of the rules. All right, thank you. The court on its own motion is going to invoke the rule of exclusion. So, Mr. Adams, you just want to wait patiently outside the courtroom until we're ready to get you. And the record reflect that Mr. Adams and another individual who is observing, well, Mr. Adams is now outside, the other individual who's now seated back there. So, all right. So this is the time set for an evidentiary hearing on this petition for injunction against harassment. Are the parties ready to proceed?
Well, actually, Your Honor, before we begin in earnest, as I was discussing with Mr. Langhoffer, my client is respectfully requesting a continuance of this hearing. I understand that a previous motion had been filed. The grounds for the continuance would be that the exhibits were ordered to be provided by July 31st. My client had not yet received the exhibits for today's hearing by July 31st. My office just received them yesterday at about 4:50 p.m. My office did file our notice of appearance about middle of the day yesterday. But regardless, my client couldn't have provided those exhibits to me because he didn't have access to them himself. And for that reason, my client is requesting that this matter be continued briefly so that the court can still respect the defendant's rights to a speedy hearing, but continued for today's purposes, Your Honor.
Okay. Anything from the defense side?
Yes, Your Honor. So first, we've uploaded the exhibits timely, both in this case and the companion case, which is not pending before Your Honor. And it's my understanding that at least through the case center system, the defendant would have had access to those exhibits. We also filed a pretrial hearing memorandum that cited a number of the exhibits and copied the defendant, of course, on that. He was before he was represented by counsel. And so they've been available. And there's real prejudice to my client from continuing this further. It's taken quite a while for us to get the records to have this hearing. We want to wait for a surveillance video to come in. And as long as this order of protection is outstanding, my defendant has lost his right to possess a firearm and defend himself, which, as you'll hear, is really, really unfortunately necessary in these circumstances.
Let me turn over to the parties, and because everyone's attorneys here, I'm assuming everyone's reviewed the Arizona Rules of Protective Order Procedure. So I'm going to review Rule 37 with everyone. the disclosure requirements in Rule 26.1 of the Arizona Rules of Procedure and Rules 49 and 50 of the Arizona Rules of Family Law Procedure do not apply to hearings on orders of protection, injunction against harassment, and injunction against workplace harassment unless otherwise ordered by the court. I didn't, because these things are very truncated. As everyone knows, we have to set these within 10 business days. That's the reason why we don't have the disclosure deadlines and everything. So rules of disclosure don't necessarily apply. So how is there prejudice when you don't have a right to really observe or have a disclosure right as promulgated by by our Supreme Court?
Correct, Your Honor. And I do recognize that Rule 37 does provide that disclosure does not apply to these kinds of hearings. However, when this court asks for exhibits in advance of the hearing, then that is a separate order of the court that's separate from the rules of procedure.
Well, I asked for that because my clerk is a human being and cannot mark things in real time. Otherwise, this 1 hour hearing would take all morning. So that's the reason why I requested those documents to be uploaded timely under the court's rule. And so again, are you saying that there was inadequate time? I guess I'm not understanding your argument, Mr. Whitaker.
Just to reiterate, Your Honor, the argument is that while the Rule 37 does not require disclosure, it's my reading of the request for exhibits in advance of the hearing that requires the early exchange. It's a court order that's above and beyond the rule. However,
But then an ordered exchange, it is ordered uploading.
Okay.
So you're saying that it's not that you didn't have a chance to review the defendant's exhibits.
that is correct, Your Honor.
Okay.
And the argument is that the informal requirement for the provision of exhibits in advance was separate and above and beyond to the rules of procedure. But
Right.
as the court has indicated, that was not the intention.
Well, upon due consideration, I'm going to deny your oral motion and continue today's hearing. Okay. So are the parties still ready to proceed?
In light of the denial of the motion to continue, my client requests to voluntarily dismiss the injunction against harassment for today's purposes.
Okay.
And Your Honor, if there's to be a dismissal, we would request that it be with prejudice.
Okay. Well, there's a specific, like everything else, there's a rule for that. Let's go ahead and review Rule 41 of the Arizona Rules of Protected Order Procedure. A plaintiff may request the dismissal of a protected order at any time during the term of the hearing. When a plaintiff files a motion to dismiss or orally request one, I'm going to personally interview the defendant. So, Mr. Richardson, can you go ahead? You can. I want you to be comfortable. So just pull that microphone to you because I want to make sure that we have a clean record. Because
Yes, sir.
as you can see, we don't have a court reporter, so this is being reported. Okay.
Oh, okay.
So can you see me through that monitor there? Or do you want me
Not through the monitor, but
but you can.
Oh, yeah, I
can
can
you.
see- I
You
can see
see me.
that.
I just want to make sure that
Right.
we can see each other.
yes.
All right. So you heard your attorney's request to dismiss this matter.
Correct.
Are you in agreement with that?
Yes.
How come?
There wasn't enough time. I was pro se beforehand, and I had a thing where the judicial assistant, she put the date as the 30th. Well, she told me the date was the 30th, but then on the email it said the 31st. So everything was confused. And the day of, I think it was Iris I spoke with. So it was just between hiring counsel and the two different dates. There was just not enough time to prepare.
Two different dates for. Are you talking about a different matter or?
When I spoke with Iris on Thursday, she told me it had to be due by 5 p.m. However, her email that she sent out said by the 31st versus the 30th.
Okay.
She acknowledged it and she said, "I'm sorry, it was an error." I mean, she was very apologetic about it, but it didn't help me in my case.
Okay. Well, with since you're in agreement with this dismissal that your attorney has made, has anyone forced you to move to dismiss this matter? Has anyone forced or threatened you?
No, sir.
So no one's like, you're not doing this under any type of duress?
No.
Is anyone coercing you to do this?
No.
So you're doing this on your own free will and accord then?
Correct.
Okay. Upon the advice of counsel?
Yes, correct.
Well, under Rule 41C, I'm to interview the plaintiff to make sufficient inquiry that the plaintiff is not doing this, making this request to dismiss this matter under duress or coercion. I have observed Mr. Richardson here. We had good eye contact, and he appears to be doing so free of any duress or coercion. He did explain the thought process behind it, but it's not under any type of duress or coercion. There's no threats or force to get him to do so. So I do find that the request to dismiss this matter is without duress or coercion. So I am going to grant the motion to dismiss. Mr. Langhofer, I know you asked for this to be with prejudice. With all due respect, I'm going to deny this without prejudice. So that's my ruling there, because we have not had a formal hearing on the merits, okay? If anyone wants to supplement the record on anything for appellate purposes, now's your chance. Not to put you on the spot, but gentlemen.
I think it probably doesn't make sense in this context, John, or if we were to put something in the record, it required testimony, and I take it that's just not what we're doing today. And so
As far as I'm concerned, for my purposes here in the Superior Court level, this matter is dismissed without prejudice. If you like to make argument about why I'm wrong, this should be with prejudice, or again, if you want, Mr. Whitaker, you want to make a supplemental argument about why I should have granted your oral motion to continue today's hearing, now's your opportunity. I just want to make sure everyone has a full and fair opportunity to make a good, clean record in case you guys decide to take me up on anything, okay?
understood. Nothing further from us, John.
Thank you.
Nothing further, Your Honor.
All right. Well, with that said, is there anything else we need to talk about today then? Before we adjourn?
Can I have a moment, Your Honor?
Sure.
Can I have just a moment to speak to Mr. Adams? Thank you. Your Honor, nothing further from us.
Okay. All right. So can you go ahead and bring Mr. Adams back? And I should have led with that. You're going to get your steps in today. So with that said, if there's nothing else we needed to talk about from either party, then this matter is going to be adjourned. I hope everyone has a good rest of your Tuesday. And stay clean out there. That air is disgusting. One more thing, there's another rule for this. The Supreme Court wants us to stagger the departure to make sure that there's no friction points as we leave the courthouse. So I'm going to ask, there's some paperwork. Plaintiff, go ahead and gather your things. Gather the paperwork, go ahead and leave. And then Mr. Langhofer, you and your gentleman, just sit tight, wait about 10 minutes and then leave, allow the plaintiff the opportunity to leave, okay?
Thank you. Will do.
Yes. It's been nice to meet you.
Yeah. Yeah. Well, we see you in 2 days. Yeah.
Thank you. Be comfortable, just
Yeah,
everyone.
thanks. So yeah. Would be correct. It is in one that's on record. Right.
All right, for sure. I called Miss Ibarra twice, left a voicemail, so I'm just gonna shoot her over an email.
All right, thanks, Miguel. Document your efforts as always, and when you're done sending the email, let's go ahead and give number 3 a phone call. Christina C, please. Good morning. My name is Commissioner Easterday, and I'm the judicial officer hearing petitions for injunction against harassment filed in the Superior Court today. Do I have Christina C on the line?
Yes, I'm here.
All right, I'm going to go ahead and call the case. This is the time set for initial / ex parte hearing on a petition for injunction against harassment. The plaintiff is Christina C. Defendant is Luis Garcia. Case number CB 2026-031764. Ms. C, can I get you to introduce yourself by saying your name on the record, please?
Christina C.
All right, Ms. C, can you please raise your right hand? Let us know when it's raised because my clerk's going to swear you in.
Okay, it's raised.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you. You can go and put your arm down now. So I'd like to first give you a quick overview of the law that I'm going to be using to decide your petition for injunction against harassment. Then I'm going to ask you some questions based upon the petition that you filed and its allegations, okay?
Okay.
So, in order for this court to grant the petition and issue the injunction against harassment you're seeking, there needs to be reasonable evidence the defendant has committed harassment against you. Now, in this context, harassment is a defined term of art, which is defined as 2 or more acts within the past year that are directed at you that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the con, in fact, seriously alarms, annoys, or harasses you and serves no legitimate purpose. Also, the acts of harassment need to be in writing in the petition with the dates the acts occurred. Does that make sense to you?
Yes.
So the petition that you filed looks like around 9 o'clock this morning. Is everything in it true and correct to the best of your knowledge, information, and belief?
Yes.
Are there any other court cases between yourself and the defendant, Luis Garcia?
Yes, there is. Well, like, what do you mean, like family court-wise, or what do you mean?
Well, are there any other court cases apart from this one between yourself and the defendant where you and the defendant are also named parties?
No, there's a civil and a criminal case going on, but I don't have the like case information for that. That's still like ongoing.
Okay, well, what other civil case are you talking about where you and the defendant are involved?
I was assaulted by the defendant at my son's football game. So I guess I'm suing him on the civil side of it for like my hospital, all my medical bills, and then the criminal side of it. The officer that I spoke with had said that they were forwarding charges to the prosecutor. So now they said it's just a waiting game of when they get to that case and we move forward with that.
Okay, let's talk about the criminal case. To your knowledge, has the prosecutor issued charges, whether by information or by grand jury indictment?
Not that I'm aware of.
Okay, the civil case that you mentioned, did you or your attorney file a complaint yet?
I believe that my attorney did. Last I spoke with my attorney was last week, and they said that they had sent over the representation over to the defendant. That's the last that I heard, though, so I'm not really.
The representation to the defendant. You mean like a demand letter, or have or was the defendant served with the process server of a complaint and summons?
Oh, no, he wasn't. No, he was not served. I'm sorry. He wasn't served with like a process server.
Okay. Do you have a court case number for that other civil matter?
No, I don't. So I'm not sure if they have filed anything through the courts yet. The last I heard is that they were speaking with his homeowner's insurance. So I'm not even sure that they've even filed anything through the courts yet.
Okay, so doesn't sound like there's criminal charges yet or another civil case yet between you and the defendant, if I'm understanding you correctly.
Okay.
Was it, in my understanding, like by case, I
Yeah.
mean like something filed that initiates a case where the clerk has issued like a CV number like the one I read off for this matter?
Oh, no. Oh, I'm sorry about that. No, yeah,
Okay.
there isn't any court, for either the civil or the criminal side yet.
Okay, all right. All right. And it looks like you've described the defendant as sons played on same football team. So you're not related to the defendant by blood or marriage by any way, are you?
No, not at all.
Okay. All right. So let's go ahead and turn to your allegations. The first allegation occurred on April 4th of 2026, in which you said that there was an altercation that happened. Not sure what that entails, but then you allege the defendant punched you on the side of your face, resulting in a fractured cheekbone. So tell me what happened on April 4th between you and the defendant.
Yeah, so it was actually after my son's football game. The defendant's son and my son used to play on the same team, and my husband used to do like one-on-one private training with him. They ended the sessions because the defendant's son moved to a different team. After the game, they ended up playing against my son, and the defendant's son had a game against each other. Everything was fine during the game. We were on opposite sides. After the game, it was a really intense game. So there was a lot of hostility walking out of the game. The defendant's team was walking out and started saying remarks to my son as well as like the other players on the team. So that was when the parents had got involved, and it was started as just a verbal argument between me, the defendant's wife, and another parent's player. We were trying to separate the kids, and then the defendant came up and punched me the right side of my face. I'm sorry. And I fell to the floor, and I don't remember anything after that. I just remember the ambulance coming, and I was transported to the hospital, where I was later told that I had a fracture and I had to be admitted for surgery.
Okay. So I hear the emotion in your voice, and I do thank you for answering my question. I know this is probably a little emotional talking about this, but I do need to know what happened. So I do thank you for that. So the defendant, so you were trying to separate, I guess, the football players, and the defendant punched you in the face, causing you to go to the ground, losing consciousness, and you were diagnosed with a fracture of your cheekbone. Is that correct?
Yes, it was a zygomatic arch fracture to the right side of my face.
Okay. And the next allegation, is anything else about April 4th, 2026 I should be aware of between you and the defendant?
No, that was the altercation that happened.
Okay. The next allegation, just kind of going in turn as you prepare on the petition, March 3rd of 2026, the defendant, Louise, confronted and physically assaulted my husband. So were you at this game or scrimmage on March 3rd?
Yes.
Okay. Did the defendant do or say anything directed to you?
After we were walking up, me and my husband and my children were walking up, the defendant came and blindsided my husband and pushed him. They had exchanged words. He did say some like derogatory remarks to me that led to just a verbal altercation in the parking lot, but nothing physical happened on March 4th. It was just the push and then the verbal argument. And then
is it March 3rd or March 4th?
I'm sorry, it was March 3rd, and then the other incident was April 4th. I got them two mixed up. I'm sorry.
It's okay. And then, okay, so you allege in the petition, quote, Louise confronted and physically assaulted my husband by pushing him at our younger son's scrimmage game. My children, as well as other children, were present when this happened, end quote. But you're saying that
Yes.
Outside of what you wrote, the defendant may have said something to you.
Yeah, it was derogatory remarks. He called me the B word. That was it. That was the only thing that he had said to me. That's why I didn't include that, because I didn't know if it needed to be like directed, like it would like confrontation between me and him directly. But it originally had started with my husband and just carried over to me. So that's why I worded it how I did.
Well, as I said earlier, the act or acts of harassment must be included in the petition with the dates they occurred. And what I have on March 3rd is that the defendant confronted and physically assaulted your husband. I didn't even know that you were there until I just asked you that question to see if anything was directed at you. The rule is pretty clear, Rule 25B, if you want to look it up. Again, I want, in case you want to look up the rules later, in the petition, the plaintiff must allege a series of specific acts of harassment or an act, blah, 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 including the dates of occurrence. And if it's not in the petition, I can't consider it as an act, okay? So
Okay, that makes sense.
what I have is, I can definitely see why you could be seriously alarmed, annoyed, or harassed by getting punched in the face so hard that your cheekbone was fractured. But that's only one incident, and the law requires two. So for that reason, I don't have reasonable evidence of harassment as defined by Arizona law. So what I'm going to do is I'm going to deny your petition. You're certainly free to do a number of different things. If you think my decision is being made in error, you can certainly appeal me to the Arizona Court of Appeals. Or not appeal me, but appeal this decision. Or you can file another petition if you think there are acts out there that were not included in, or that could meet that definition, like being called a derogatory term. Again, that derogatory term is not in this petition, okay?
Okay.
So for that reason, I'm going to deny your petition, and you have different options. Okay? You have any questions for me?
No.
Sorry, I didn't catch that.
No, I don't.
Okay. Well, I am sorry that I hear the emotion in your voice. I am sorry about that. But if there's nothing else, this matter is adjourned, and I do hope you have a good rest of your day, okay?
Thank you. Actually, I'm sorry. Is it
What's-
too late to ask a question?
Yeah, no, we can go back on the record. What's your question?
Okay. So if I'm able to submit a new petition stating with the derogatory mark, is there a possibility that it would be able to be granted, or how do I go about trying to do that?
Well, I can't rule upon things that haven't been filed yet. But again, you're certainly
Okay.
free to file another petition now that you know a little bit more about the law and what we judicial officers are looking for. You can certainly use your newfound knowledge to file another petition or petitions. Okay?
Okay, thank you.
You're welcome. If there's nothing else, this matters adjourned. I do hope you have a good rest of your day. Okay.
Thanks, you too.
All right, if everyone's still ready, let's go ahead and give number 4 a phone call. Casey Collins, please.
Sounds good. I'll give her a call, Commissioner.
Good morning. My name is Commissioner Easterday, and I'm the judicial officer hearing petitions for injunction against harassment filed in the Superior Court today. Do I have Casey Collins on the line?
Yes, sir.
All right, I'm going to go ahead and call the case. This is the time set for initial / ex parte hearing on a petition for injunction against harassment. Plaintiff Casey Collins, defendant Jessica Gatrell, case number CB 2026-031763. Can I get you to introduce yourself by saying your name on the record, please?
Casey Collins.
All right. Ms. Collins, can you please raise your right hand? Let us know when it's raised because my clerk's going to swear you in.
Go ahead.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, yes.
All right, thank you. Go and put your arm down now. So
Thank you.
I'd like to first give you a quick overview of the law that I'm going to be using to decide your petition for injunction against harassment. Then I'm going to ask you some questions based upon the petition and its allegations, okay?
Yes, sir.
So before this court can grant the petition and issue the injunction you're seeking, there needs to be reasonable evidence the defendant has committed harassment against you. Now, harassment in this context is defined as 2 or more acts within the past year that are directed at you that would cause a reasonable person to be seriously alarmed, annoyed, or harassed in the comment. In fact, seriously alarms, annoys, or harasses you and serves no legitimate purpose. Also, the acts of harassment need to be in writing in the petition with the dates the acts occurred. Does that make sense?
Yes, sir.
All right. So first question for you is, the defendant, Jessica Gatrell, do you have any other court cases between yourself and the defendant?
I myself, no.
Okay. The petition that you filed, is everything in it true and correct to the best of your knowledge, information, and belief?
Yes, sir.
You described the defendant as ex-wife of my current girlfriend, so you're not related to the defendant by blood or marriage by any means?
No, sir. No, sir.
And you don't have a romantic relationship with the defendant too, correct?
No, sir. No,
Okay.
sir.
So let's go ahead and turn to your allegations. I'm just going to take them as you've alleged them in the petition. First one looks like it occurred on May 2nd of 2026. Quote, entered house I am currently staying at, broke things inside house, police case number, looks like a DR number. So,
Yes.
well, did the defendant enter your home? Because who entered your home first off?
Jessica, the defendant, yeah.
Okay.
It's the home that I'm staying at. It's not actually my home.
Okay. Well, and then you also alleged broke things inside the house. I'm assuming Jessica entered the house and then broke things inside the house?
Yes. Yes, sir. And I have pictures as well.
Well, whose things did she break?
Some of mine and then some of Tatiana, which would be her ex as well.
Okay.
So it's the house that I'm staying at with her ex.
Okay. Well, were the defendant's actions directed more at the, I guess, her ex, the homeowner of this place?
No, it was more towards me.
How do you know that?
When she entered the house, I was upstairs and I had locked myself in the room and she was yelling like my name. She was like, Casey, come down here, I'm gonna get you, and things like that as she was destroying things downstairs.
Okay, so you heard things crashing, and while the defendant calling your name, coming, asking to, I guess, to come see you, correct?
Correct, yes, sir.
Okay. All right. Next allegation occurred 2 days later, May 4th, 2026. Quote, threatening voicemails left to cause harm to me. Well,
Yeah.
Who left who left the threatening voicemails?
Jessica.
Okay, so Jessica called your cell phone?
Yes, sir. Mhm.
Okay, so the defendant called your cell phone and then left voicemails. What did the voice, how many were left on May 4th?
Just one, and it says, "I promise you, Casey, I'm coming for everything that you have. Keep going over there," meaning going over to the residence that I'm staying at. "I promise you, I'm going to lose my mind on you, and I'm going to come get you."
Okay, how did that make you feel when you reviewed that voicemail?
Scared for my safety.
Okay. The next allegation occurred on May 17, 2026. Quote, voicemails left threatening to harm me at my son's high school graduation. So I guess similar question. Who left you the voicemails on May 17th?
Jessica.
Okay, so the defendant, how many voicemails? Because we've got plural here, so how many?
On the 17th, just one.
Okay, so left a voicemail on the 17th. What did it say?
Mhm. Let's keep going. Let's do this. I don't know why you're answering, you scared bitch.
Okay. When you reviewed that voicemail that the defendant left you on your cell phone on May 17, how did that make you feel?
Scared for my safety.
The next allegation occurred the next day, May 18, 2026. Quote, voicemail left threatening to show up at place of employment, end quote. So, similar
Yes,
question.
So Jessica called him.
Okay.
Jessica called and left 3 messages this day.
Okay, so not just voicemail, there's multiple
There's
voicemails.
voicemail, sorry. There's multiple voicemails on the 18th, yes, sir.
Okay, so what time was the first one?
The first one was 10:57 p.m.
Okay, what did it say?
This one says, Allie and Anna, which were my 2 oldest daughters, were right. I should have whooped your ass when I had a chance. I will, and I promise you, don't ever go back to work. I will be there every day until I get you.
Okay, how did that make you feel?
Scared for my safety.
What time did the second one come in?
11:21.
What did that one say?
So Jessica and Tatiana have a child together. So this one said, remember, if I don't get my child back today or tonight, the cops don't find you, then on Wednesday, when our babies graduate, I promise you I'll fuck everything up, including Casey. So get that.
She referred to you as Casey?
Yeah. So
Was this
it's because
was
me
this
and
on your
Tatiana,
was this
it's
on
on
your
my
cell
phone, but it's on my cell phone, yes. But Tatiana was with me. So I think she said that so that in hopes that she would hear as well as myself.
Okay, so the second voicemail, who was that directed to?
Myself and her ex, I would say.
Is it a question or a statement? I'm asking you.
It was directed at the both of us.
What about this third voicemail that came in on May 18?
The third one states,
What time?
sorry, this one was at 11:16, so I skipped this one before the other one. I clicked the other one. This one says, I promise you, Casey, you can't miss work forever, ho. If you can't take care of your own kids besides playing set mine to mine, that's fine. It's fine. I got you.
Okay, was this directed towards you, do you think?
Yes.
How did that make you feel when you got this one at 11:16?
Scared for my safety.
And then the last allegation, also May 18, 2026, threatening voicemail left. Did we talk about all? Did we talk
Yeah,
about?
we did. Yeah, I must have entered an extra one on there because there's just 3 from the 18th, 1 from the 17th, and 1 from the 4th.
Okay. Well, based upon my review, I'm going to grant the petition. Specifically, I do find reasonable evidence of harassment of the plaintiff by the defendant. Therefore,
Okay.
I'm granting the petition. Therefore, the defendant shall not commit an act of harassment against the plaintiff. You've asked numerous individuals to be included in this, and
Those are my 4 kids. And it's only because she's including them like in those voicemails. So I was just including them in the petition.
okay. Well, it's based upon what you've told me, all the acts of harm were directed at you.
Okay.
Has she,
That's okay.
well, my question to you is,
Sorry.
is there any, is my understanding incorrect in any way?
No. It's everything's been directed at me. I just more so added them in there just as like a safety thing, really.
Well, because all the acts of harassment were directed at you, I'm not going to include Alexavier Collins, Adriana Villagomez, Allison Villagomez, or Adeline Villagomez. But if circumstances change, you're certainly free to file a motion to modify, or if there are acts that begin to be directed at any of these other individuals, and it sounds like you're a parent, there is a mechanism that you can file a petition on behalf of one of your minor child or children, okay?
Okay.
So the defendant shall have no contact with plaintiff except through attorneys, legal process, court hearings. The defendant shall not go to or near the plaintiff's residence. I'm going to confirm your address is 9410 South 33rd Drive, Levine, Arizona 85339. Is that correct?
Correct.
You've also asked the defendant to stay away from your workplace. You work at Simon Med Imaging, 5410 West Thunderbird Road, Glendale, Arizona 85306. Is that correct?
Correct.
Okay. And specifically, she even mentioned going to your workplace to potentially harm you, if my memory serves me correctly. Is that correct?
Correct. Yes, sir.
Does she work, just out of curiosity, does she work at this same Simon Med Imaging? Or does she just know that?
No, she used to work for the company. So she knows that I work here.
Okay.
But she's no longer employed with the company.
Okay. You've also asked the defendant to stay away from school or other, but no school or other is listed.
It would be that would just be including because of the kids, but with them not being included, that wouldn't be applicable.
Okay, and then there's a contact with a Peoria address. What is this?
The Peoria address is my old address.
Do
That's
you,
where the kids are staying.
okay,
It's is it the 8670 North?
Correct. Do you stay at this address? Do you reside
I
at this address?
don't, but I go over there to see the kids. So I'm there. That's where my kids live with their father. So I do go over there, but I'm not like residing there.
Okay, so you visit that place because you share custody
Correct.
with
Yes,
the
sir.
biological father. Okay. Well, I'm not going to
Correct,
include
sir.
this address. It's certainly when you're there, the defendant is not to be there because, as I said earlier, the defendant shall
Right,
have
because of
contact
the
with you.
order.
But I'm not going to include that contact in my order otherwise. Okay.
Okay, sounds good.
So, all right. So I'm granting the petition. So let's, while I have you here, I want to talk about what you can expect. So in the very near future, you can expect to receive an email from my court staff. The email is going to contain various documents. One of those documents should be, I guess, kind of like a next step guide. But again, since I have you here, I just want to kind of hit the highlights for you. So the court's order, the injunction against harassment, does not go into effect unless and until the defendant is personally served.
Correct.
Under Arizona law, the only individuals that are allowed to serve the defendant are either a licensed process server or local law enforcement. That can include the sheriff's office, Phoenix Police, Glendale Police. If and when the defendant is personally served, that's when the order will go into effect, and the order will last for 1 year from the date of service. Anytime during that year in which the order is in effect, the defendant can object, and if she files a written objection, this court will schedule an in-person evidentiary hearing where this court will take evidence. I mean, this court, I'm going to stop referring to myself in the third person. I will take evidence about whether A, the allegations occurred, and B, meets the definition of harassment. You and the defendant will have an opportunity to call witnesses, cross-examine the other party's witnesses, and introduce any other evidence that could be relevant, like screenshots, print-offs, video recordings, audio recordings, anything that's relevant to whether A, the allegations occurred, B, meets the definition of harassment. Any questions about what I just hopefully gave you a quick crash course on?
So for you, how you said it has to be served, do I just reach out, like call the non-emergency number and ask them to serve her? Or how do I go about that?
You know, I think every agency might be a little bit different, but these laws have been around for quite a while that if you, it's definitely not, I mean, don't call 911.
No, I said the
I mean,
non-emergency.
call 911 in an emergency, but if you reach out, I guess using, like you suggested, the non-emergency line, or there might be a dedicated line online for these orders. I'm not entirely sure. Every agency, every
Okay,
police
I'll
agency is a
take
little bit
a look.
different. But yeah, you can certainly reach out to your local law enforcement agency of choice, and they should be able to, tell them that you need an injunction against harassment served. They should be able to pick up what you need, what they need from you from there. Okay.
Okay.
Any other questions?
No, sir.
All right. Well, if there's nothing else, then this matter is adjourned. I hope you have a good rest of your day. Okay. All
You too. Thank you.
right. Bye.
Commissioner, whenever you have an opportunity, Marlene Ibarra for number 1 and 2 did reach back out. And I did ask her to keep the phone close. So whenever you're ready, we can always circle back to that.
All right.
No
Thanks.
new ones.
Okay, Miguel, let's give Marlene Ibarra a phone call back, please.
Sounds good.
Good morning. My name is Commissioner Easterday, and I'm the judicial officer hearing petitions for injunction against harassment filed in the Superior Court today. Do I have Marlene Ibarra on the line?
Yes. Hi, good morning.
Good morning. I'm going to go ahead and call the two cases. This is the time set for initial / ex parte hearing on a petition for injunction against harassment. Case 1 is plaintiff Marlene Ibarra versus defendant Teresa Michelle Gutierrez. That case number is CV 2026-031723. Case number 2 is plaintiff Marlene Ibarra versus defendant Jose Alonso Gutierrez. Case number CV 2026-031754. The reason why this court is going to hold, I guess, one phone call for these two independent and separate matters because, well, we have one plaintiff and we don't want to waste her time by calling her, hanging up and calling her back. So that's the reason why we're doing it this way. So, Ms. Ibarra, can I get you to raise your right hand? Well, first off, can I get you to introduce yourself by saying your name, please?
Marlene Ibarra.
All right, Ms. Ibarra, can you please raise your right hand and let us know when it's raised? Because my clerk's going to swear you in.
It's right.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you. You can go ahead and put your arm down. Now, I'd like to give you a quick overview of the law that I'm going to be using to decide each petition independently of one another. But I do find that it's kind of helpful to have an idea of at least an understanding about the law that I'm applying, so you have an understanding about why I'm doing what I'm doing when we eventually get to that point, okay?
Okay.
So there's two ways in which I can grant either petition or petitions or deny them. The first is there needs to be the first way is reasonable evidence the defendant has committed harassment against you. Now, in this context, harassment is defined as 2 or more acts within the past year directed at you that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses you and serves no legitimate purpose. The other way is if a good cause exists to believe that great or irreparable harm would result to you if the injunction is not granted before the defendant or defendant's attorney can be heard in opposition, and there are facts from you about your efforts to give notice to the defendant or reasons supporting why no notice should be given. That's a mouthful. Basically, in essence, great irreparable harm would lead, in my understanding, is that death, serious physical injury, or serious amounts of property damage would result, could result, or would result to you if I do not grant the injunction. Does that make sense?
Yeah.
All right, so two different ways. So no matter which way the court decides, or which way, no matter what, the acts of harassment need to be contained in writing in the petition with the dates the acts occurred. Does that, so hopefully that clears up anything. Hopefully I'm not confusing you too much. I'm kind of confusing myself, but any questions
I'm
about
kind
what,
of getting a little, but
any questions about anything before we proceed any further?
no.
Oh, okay. So let's go. I just want to take each case in turn because each petition is going to be analyzed separately and independently from one another. So first case we're going to talk about is you versus the defendant Teresa Michelle Gutierrez, case number CB 2026-031723. First thing, this petition that you filed against the defendant Teresa Gutierrez, is everything in it true and correct to the best of your knowledge, information, and belief?
Yes.
Are there any other court cases between yourself and the defendant Teresa Gutierrez?
No, but she did file a injunction of harassment towards me. So I was going to actually go down to court to try to fight that because I don't believe I should have one.
Okay, so there is a court case out there between you and the defendant then?
Would that be a court case? The injunction?
Yes. Does it? It has a CV number and everything.
Yes.
All right, and were you served recently?
Yes. So actually, on the second, me and my children had got shot at.
Well,
I don't know.
again, I'll get to your specific allegations, but I want to know about any other court cases between yourself and the defendant.
I just believe that the harassment. Yes.
Okay. You've listed the defendant as your neighbor, so is that correct?
Yes.
So you're not related to the defendant by blood or marriage by any way?
No.
Okay. All right. So turning to your allegation against defendant Teresa Gutierrez, you allege that she had her brother follow us, Jose Alonso Gutierrez, followed me and my children. So what did the defendant do or say directed to you on August 2nd?
Directly to me on August 2nd, she didn't say anything to me directly to me on August 2nd.
Okay, so she didn't say anything directed to you or do anything directed to you on August 2nd. We're talking like Sunday.
No, I did not see her at all.
Okay. Okay. All right. So anything else that I should be aware of between yourself and the defendant Teresa Gutierrez for things that occurred or not occur on August 2nd?
No.
Okay. Okay. Well, before I proceed any further, I am going to, based upon everything before me, I'm going to deny the petition involving the defendant Teresa Gutierrez, CB 2026-031723, because I do not find reasonable evidence of harassment. Okay. So let me just. So just give me 1 second while I do something here, okay? Sorry, this is taking a little bit longer than I anticipated. I do apologize about that.
Mm-hmm.
Okay. Let's go ahead and move on to the petition involving you and the defendant Jose Alonso Gutierrez, CV 2026-031754. So, Ms. Ibarra, you're still under oath. Let's talk about you and the defendant Jose Gutierrez. The petition that you filed earlier today involving Jose Gutierrez, is everything in it true and correct to the best of your knowledge, information, and belief?
Yes.
Are there any other court cases between yourself and the defendant Jose Gutierrez?
No.
Okay. You've listed the defendant as your neighbor, is that correct?
Yes.
So you're not related to Jose Alonso Gutierrez by blood or marriage anyway, correct?
No.
Okay.
No.
All right. So turning to your allegation on August 2nd, 2026, it looks like this defendant, Jose Alonso Gutierrez, followed you and your children. So tell me what happened between yourself and the defendant on Sunday, August 2nd.
Well, like I said, I didn't see nobody. Me and my kids were going in the car. I was going to go get my son a haircut and return some clothes at Didi's. As we go down 23rd, or we go down Glen Rosa, as we go to the stop sign, we're just driving slowly, like I wasn't even paying attention. There's this white truck come hauling out of nowhere, hauling past us, and I'm like, hey, like there's kids in here. Like,
I'm sorry,
and
Mr.
he
Barrett,
like,
you're very muffled, so I'm not, it's hard to hear, it's
oh,
hard to
I'm sorry.
follow.
I'm sorry. Can you hear me now? I'm sorry.
That's much better, thank
It
you.
was a little far. Okay, my apologies. And he like hauls past me, and I'm like, hey, you idiot, like there's kids in here, and he turned to like flipped
Who's
a
he?
U-turn. Jose, he flipped a U-turn, and he's like, F you and your kids, and then let off 6 rounds. And I pulled over, like literally maybe a feet or two over, and my kids ran inside the church, and I called the police department.
Okay, so the defendant drove past you quickly, and you told him, hey, there's kids here, and and so it's the defendant, Jose Alonso Gutierrez.
Mm-hmm.
Said yes?
Yes.
Okay. And he flipped a U-turn, and then you said and wrote, let off 6 rounds. What does that mean?
He shut off 6 rounds.
Okay. Where was the gun pointed when he fired the 6 rounds?
Me in the vehicle, and my kids were in the vehicle.
Okay, so the defendant got a weapon, pointed it at the car that you were and your children were sitting in, shot and pulled the trigger 6 times,
Yes.
and struck, and you said 3 bullets penetrated the vehicles.
Yes, one in the front of the vehicle, one on the hood of the car, and one in the tire, the driver tire.
Okay, so struck your vehicle 3 times?
Yes.
Okay, so you wrote penetrated the vehicles, plural. So any other cars that you own?
No.
What?
No.
So, okay, so it's just your vehicle then, singular.
Yes.
Okay. And then, so after the defendant fired the 6 rounds, what happened next?
I pulled over. I told my kids to run into the church, and I called 911.
Did police arrive?
Yes.
Did the police investigate?
Yes, and they found casings, and they also found him as well.
Okay, what did the police do when they found him?
They had us on 2 separate sides, so when I was asking, it was just worry about my side, so I don't know honestly.
What do you mean on your side?
I don't know where they had got him. I was with the police officers from 4 o'clock, and they let me go around 9, 10ish at night. So I guess and wherever they caught Jose, wherever he took off from when he fled the scene, that's what I meant. I was on one side on 23rd Ave, and he was somewhere else, like on another part, wherever they got him. So I don't know.
So you
Really what?
you interacted with the police, and the police found him at a different location.
Yes.
Okay. Did the police arrest the defendant?
Yes.
Is he booked into jail, to your knowledge?
Yes. Yes.
Is he out on bond, or have you been notified by victim services about your victim's rights? Have you had notice of an initial appearance or probable cause hearing?
No, but I do see that he was just booked in, charged in. But I haven't got any like notifications or anything like that.
Okay. When was he booked into jail, to your knowledge?
I believe on the 2nd.
Okay. Also on Sunday. Do you know if he's been released from custody?
I had called and it had said that some charges were bondable, and then it had said that some were unbondable. So I'm not quite sure how that works.
Okay. So unbondable. Okay. All right. So so the defendant was arrested and booked into jail, and to your knowledge, he's still in custody?
Yes.
Okay. Is there anything else I should be aware of you want to tell me about this matter?
No, just I don't know. None of it makes sense to me. None of it makes sense. No, I'm sorry.
Oh, okay.
No.
That's okay. Okay. So based upon my review of the verified petition and by the plaintiffs under oath statements, I am granting the petition. Specifically, the court finds that great irreparable harm would result to the plaintiff if the injunction is not granted before the defendant can be heard in opposition. There are specific facts attesting to the efforts to give notice to the defendant. Well, she hasn't given notice to the defendant because the defendant, after the alleged incident occurred on August 2nd, was arrested and booked into custody that same day. And there are also reasons why notice should not be given as well. The defendant is currently in custody. So in this quick set hearing, this court cannot get the defendant on the line before we can move forward. So those are the reasons why, the specific reasons why notice is not being given prior to issuing this injunction. So I am granting the petition. I am finding that great irreparable harm would result to the plaintiff if the injunction is not granted before the defendant can be heard in session. So therefore, it is ordered the defendant shall not commit an act of harassment against the plaintiff. The defendant shall have no contact with plaintiff except through attorney's legal process, court hearings. The defendant shall not go to or near the plaintiff's residence. I'm going to confirm your residence is 2332 West Glen Rosa Avenue, apartment 179, Phoenix, Arizona 85015.
No, 173. 85015.
What's 173?
The unit number?
Yeah. Oh, so it's apartment 173, not 179.
No.
All right, so it's 2332 West Glen Rosa Avenue, apartment 173, Phoenix, Arizona 85015.